We are recording this webinar for those who were not able to join us today and any of you who would like to watch the content back at a later time. So we'll be sure to share the recording via our social media platforms and our public policy newsletter that goes out every other Friday. So just as a courtesy, please remember to shut off your microphone. You are welcome to keep your camera on or off, whatever you would like to do. So I'll go ahead and get started now. I'm going to ask my friend and colleague Allycia Wolff to go ahead and share her screen. We've got a PowerPoint presentation ready for you today.
It's probably not good.
And just a friendly reminder to please shut off your microphone if you are joining the webinar today. And I'll ask my other team members from the ARC Minnesota to help with that if we need it. So again, thank you everyone for coming. I'm Alicia Munson, Public Policy Director with the ARC Minnesota. My colleague Alicia Wolff, Advocate Allycia Wolff, is joining me for this presentation today. And we'll go to the next slide. So just a high-level review of the agenda. First, we're going to share with you a little bit of background about our efforts around updating Minnesota's guardianship statute during this past legislative session, and the coalition that we engaged in. We're also going to give a little bit of background about why we felt it was so important for some of the changes and updates to the guardianship statute to be made, and really talk about some of the most important pieces that we feel are impacting the ARC Minnesota's stakeholders statewide. And then Alicia's going to give a great overview of some of the decision-making support options that are available to folks other than guardianship. And we'll do a very, very high-level review of a couple of the resources that our team at the ARC has developed that'll go hand in hand with this webinar. So we'll go to the next slide. As you all may know, the ARC Minnesota is a statewide nonprofit advocacy organization that works to promote and protect the human rights of people with intellectual and developmental disabilities, supporting them and their families in a lifetime of full inclusion and participation in their communities. And along with that, the ARC Minnesota also has several public policy values that really align with those critical components of our mission. All of the ARC Minnesota's public policy work is grounded in these values of human and civil rights, self-advocacy, self-direction, and equity and true belonging in community. And because of those values, we felt like it was really important to be part of a team that was taking a look at Minnesota's statute, finding areas that we needed to update the statute to really promote self-direction, promote true belonging in community, make sure that people with disabilities have control over as much of their decision-making in their life as possible, and make sure that guardianship and other support options in decision-making are really tailored to meet an individual's needs. So again, they can maximize, their control over their decision-making in their life. So a little bit of background about when this all got started, our public policy efforts around guardianship modernization. This really began several years ago in 2018 when the Uniform Law Commission made some recommendations for best practices for state statute, for state laws around guardianship. And a group of experts in Minnesota started getting together to say, okay, what are the recommendations that the Uniform Law Commission has made? And what are other things that Minnesotans might want to change about our guardianship law to really best reflect current practice in guardianship? And again, like I said, make sure that individuals have as much control over their decision-making and autonomy in those decision-making processes. So a couple of the key partners that were very, very involved in that effort were the team at the Elder Justice Center, specifically Sean Burke, folks at the Minnesota Disability Law Center, like Jennifer Geeson and Murren Holden. The Minnesota Consortium for Citizens with Disabilities, a really broad-based nonpartisan group of disability advocates, worked together on this, as well as folks like Anita Raymond from Volunteers of America, her colleague John Kantke, who's an expert in guardianship law and an attorney himself, and then providers that do private guardianships like Lutheran Social Service. I also want to give a special shout out to Bob McLeod, who's an attorney and provided so much technical expertise in drafting the bill language. Really, it was this team and quite a few others who are all members of the Working Interdisciplinary Network of Guardianships stakeholders, WINGS Minnesota. It's a really long acronym, you guys, so I apologize. WINGS Minnesota, who were really actively engaged in this process over the course of 2 years. We went through more than 14 different versions of the draft bill language in order to get it right. And we also did some intensive outreach to stakeholders across the state. The ARC Minnesota, for instance, talked about the proposed changes with members of our regional quality councils. We worked with members of our public policy committee. We talked about the changes with members of self-advocacy groups statewide to really make sure that parents, family members, individuals with disabilities had a chance to take a look at and give feedback about the draft bill language. And then during this past legislative session, we were really lucky to have some fantastic authors. In the House, we worked with Representative Kelly Moeller. She was a member of the Judiciary and Civil Law Committee. She's a Democrat. In the Senate, we worked with Senator Bill Ingebrigtsen. He's a Republican, also a member of the Judiciary Committee. And Senator Ingebrigtsen has a personal connection to this too. He and his wife are the guardian for a family member with disabilities. So a broad range of lived experiences there. And these two champions were just so important in making sure that we were able to get hearings in the judiciary committees and have the conversations that we needed to with elected officials to help them understand the changes we wanted to make. And we were really fortunate to get this through. It was such an interesting legislative session, as I'm sure you all can imagine, given the COVID-19 pandemic and all of the ways that we had to kind of change the process of legislative advocacy for social distancing and doing everything remotely. But thankfully, we made a ton of really good progress before the pandemic hit. And so I'm really excited to say that we were able to get this bill passed during the regular 2020 legislative session. So that's a little bit of background about our public policy work around this. And now I'm going to turn it over to Allycia Wolff to share with you more details and information about some of the specific changes in the bill that we think are really important to highlight. So Alicia, I'll turn it over to you.
Thank you, Alicia. So my name is Allycia Wolff, also another Alicia here at the ARC. I want to thank and recognize Alicia Munson for the incredible amount of work that she put forth in all of the collaboration with the Modernizing the Guardianship reform. Along in that second bullet, along side of all of these wonderful organizations is the ARC Minnesota and Alicia and all your work. So thank you for being a great champion to this. Okay, so we here at the ARC know that people with disabilities and everybody in our community has the ability to learn and grow over time. And you can see it here in this fixed mindset versus a growth mindset graphic that I pulled up from Google. And it is the thought and the knowledge that intelligence is changeable and exponential and it grows over time. And the reason that we have put so much work into modernizing this guardianship statute is because we know that people learn how to make decisions over time. And people learn how to make better decisions over time. The decisions that I made when I was 18 are very different than the decisions that I made when I was 28 and that I will at 38. And it's because we have lived experience and we learn from those experiences. We learn from mistakes and we learned from things that went well and things that didn't go well. We have been so passionate about making sure that guardianship statute reflects this ability for people to learn and grow over time, and that's why we've put so much work into it, and that's why we're really excited about the statute change. Like Alicia had mentioned, this was one of the things that went through in the last legislative session, even regardless of COVID, because it is a bipartisan bill, and it has positively affected so many people. So one of the first changes that we want to mention is language updates. So I'm going to go through first some high level big piece of changes that the statute covers, and then we'll get into like the details. But one of the first things was the term ward was stricken from the statute, and it changes to person subject to guardianship. We felt strongly that ward was a old language that didn't have a good connotation with it, and it didn't represent people who were subject to guardianship well at all. So we changed that. So ward is no longer in the statute. If you hear it moving forward, it probably is just out of habit of people using that term, but we believe that humans should be seen for who they are and not subject to that term ward. So it's person subject to guardianship now. And there is a new definition for supported decision-making. So supported decision-making in statute is defined as, it means assistance from one or more persons in an individual's choosing in understanding the nature and consequences of potential personal and financial decisions, which enables the individual to make decisions and when consistent with the individual's wishes in communicating a decision once made. Basically, that means that a person is supported in decision-making. So it's explained there in a really eloquent way, but it means that there's people in your life that are going to help you make decisions about something happening in your life. So if we think about if you were to have a knee surgery, there's no way that you would have all the information that you would need to be able to make the decision about that knee surgery. So you look to your doctor, you look to friends that have maybe also had that knee surgery. Those are all people who are supporting you in that decision making. And this is what the courts now are going to be putting a much higher focus on, is let's see who is in your life to help you make these decisions so that you can move forward with getting that support in making decisions instead of removing your decision-making right altogether. So the court is really trying to make sure that people can retain their rights to make decisions and have that support moving forward. There was also an update to the term incapacitated person, and that is defining who may be subject to being placed under a guardianship based off of what is listed there. So is impaired to the extent of lacking sufficient understanding or capacity to be able to make personal decisions in the areas of medical care, nutrition, food, shelter, safety, and of course, that is subject to the conversation that would be had with an attorney and a judge in the court. So like I mentioned, there is a greater consideration of less restrictive options. In the past, there hasn't been as much of a conversation about, hey, have you tried less restrictive options before seeking a guardianship? And so now it's in statute that judges ask, and families and attorneys have to say, here, we have tried this, this, and this, and this thing before going for a restrictive guardianship. Now, Minnesota is following a handful of states who have already led this movement, if you will, in decision-making supports and guardianship. States like Texas and Delaware and Wisconsin have supported decision-making laws in statute. So we're kind of just trucking along with this modernizing guardianship because, again, we know that people have the ability to grow and change and learn in time. So what this means is that now moving forward, all of the statute laws started, all the new statute, all the reform started on August 1st. So from here on forward, before a restrictive guardianship is placed over a person, the courts and the judge are going to say, hey, why have all of these things on the right-hand column here, why have they not been enough to support a person in guardianship, or in decision-making rather? So the court prefers people utilize these less restrictive options to help people in decision-making before restricting the rights through guardianship. The guardianship petition considered by a judge must now include the alternatives that were considered and tried, how long the alternatives were tried, the details of why these alternatives did not work, so why they're not enough to support a person, and the unmet decision-making needs that a person still has, and therefore why the guardianship is necessary. So usually when I'm talking with families about decision-making supports moving forward, I'll go through all of these less restrictive options with family members and caregivers to talk about what specifically they are and what kinds of help a person needs in decision-making. Because it has been a conversation for a really long time that if you have a disability, you need a guardian. And that's what we're changing. Just because somebody has a disability diagnosis doesn't necessarily reflect an ability or inability to make decisions. And so we're challenging that. And we're saying that even if you do need help in making decisions, there's a lot of ways that you can get that help without it requiring a court process and without it requiring a restriction of rights. So supported decision-making and circle of support, a circle of support is like the people that you have around you in your life. You can do a release of information form with a doctor's office or with schools. A power of attorney can be a good resource. A representative payee, if somebody is receiving Social Security, a rep payee can be the person to help an individual manage that Social Security payment. An authorized representative is somebody who supports with medical assistance in the application and managing that medical assistance, a joint bank account, an ABLE account, which I'll talk a little bit about later, and some estate planning are a few of the options for less restrictive options. So this is a graphic that I borrowed from the ARC Wisconsin, to give credit to them. And they had a really wonderful representation of how people can get supports in making decisions on a continuum that is less limiting to more limiting. So if you see on the left here, a release form, a release of information that you would sign with the doctor's office or with a school, would be less limiting. You would be able to share information with people. Your parents could still talk to your teachers or your doctors. You could still get help, but it wouldn't be limiting your ability to make decisions in the end. It would involve people to step in and be of a greater support to you in helping you process what decisions you have and how to choose between the options in front of you. There's also supported decision-making agreements, a representative payee, and then it gets into the more limiting things like the power of attorney and the limited and full guardianship. A power of attorney, you are consciously and willingly giving decision-making abilities to somebody else. You're signing on to that. You're giving that right to somebody else. Guardianship, of course, is granted by a judge. And then time-limited guardianships is a great thing that is in the new statute that we're really excited about. And basically what this means is that any person who is 30 years old or under who's determined to need guardianship must have a time-limited guardianship, meaning that this can last 72 months or up to 6 years at most. So if somebody turned 18 and it's determined that they need a limited or a full guardianship, then it will automatically be a time-limited guardianship, meaning that in 6 years, you'll have to go back to court if necessary to continue to prove the need for guardianship. And we deem this as a great success because there's a lot of people who are placed under guardianship at 18 because at that point, it's determined that they need that level of support. But like I said earlier, the decisions that we make when we're 18 are very different than the decisions we make at 28 and 38 and so on, because people grow and learn over time. And when people have the autonomy and the ability to make choices themselves, it helps people know how to make choices and decisions better in the future. I remember when I first turned 18, I had a fight with my mom because she made me call my insurance company to argue a bill that I got for like an allergy test or something like that. And I fought her tooth and nail on that. I did not want to call the insurance company because it's really intimidating. Health insurance is really intimidating. But my mom walking me through that and forcing me to call and giving me guidance made it so that now I can call a healthcare insurer with, you know, I still don't want to do it, but I can do it without that anxiety to go along with it. So the time-limited guardianship is really encouraging people to think about the future and not have guardianship be for the entirety of somebody's life. A judge can limit the time of any guardianship, even for people who are older the age of 30. So if a guardianship is established for somebody over 30, they can still do a time-limited guardianship. And then at the end of that 72 months or whatever the judge determines is that time limited, the guardian can encourage the person to use alternatives to guardianship. So moving away from that restriction of rights of guardianship and then more into the alternatives, like I've mentioned on the previous slides, or to go back to court to petition for guardianship again. So at the end of that 6 years, if nothing happens, if nobody petitions to reinstate that guardianship or do that guardianship again, then it will be as if the guardianship would just be annulled and the person can be supported through alternatives. So this also encourages people to have that continued ongoing conversation about, hey, is this necessary? Let's not restrict rights unless it is a process that really is needed to support somebody. And as I'm giving this presentation, please feel free to enter any questions in the chat box. We'll have time at the end to go over things in more detail. So there was a lot of language added to strengthen the Bill of Rights. Okay, so I just got a note from Alicia Munson, and it is important to note that for the time-limited guardianships, it's not retroactive. So it's only moving forward anybody from August 1st, or rather like today, moving forward would be subject to the time-limited guardianship. So if there's already a guardianship established, then it's just going to continue. So the Bill of Rights, there was a lot of additions to the Bill of Rights because we wanted to make sure that people that were under guardianship and subject to guardianship still had a lot of civil and constitutional rights that allowed people to have that dignity and strength. And so it was added that guardians are required to acknowledge individual preferences for medical care or other decision-making. People have access to employment and employment supports, have choice in aspects of life unless delegated to the guardian or conservative a court order. So as many of you know, guardianship in the state of Minnesota has 7 different powers. There's 7 powers of guardianship. So the Bill of Rights now is explicitly saying that anything that falls outside of those 7 powers of guardianship is of complete choice of the person under guardianship. And that's if the guardian has a limited guardianship. So if they only have 4 out of those 7 powers, anything that the guardian doesn't have explicit power and control over, the person has, that's their own decision. Additionally, people have the right to make decisions about their clothing, furniture, vehicles, and other personal property. Be consulted about and make decisions on personal image and name unless otherwise noted by the court. So the ability to give your permission if your photo is being used or if your name is being used in a story or something like that. And a big one that was added to the Bill of Rights is to build and maintain relationships with people of their choosing. So if a guardian feels that the person subject to guardianship is in danger, then the guardian can limit who they interact with, but this is only if the guardian knows that the person is risk to physical, psychological, or financial harm. And then in order to limit that interaction, they must provide written notice to both of the people and the court before they can limit that interaction. The person subject to guardianship or the person whose visitation permissions are being restricted can ask the court to remove that restriction. So it's enabling more communication, more conversation, more awareness of why that restriction is being made. And additional changes. So guardians can set up ABLE accounts now, whereas in the past, prior to August 1st, the person with a disability had to set up the ABLE account. The guardian can set up the ABLE account, but the guardian cannot manage the ABLE account because a guardian does not have any financial power over the person under guardianship. So a guardian can set up the ABLE account, but not manage the ABLE account. They can still, a guardian can still, or anybody could still support somebody who has an ABLE account in the background, right? You know, like how my mom did when I was trying to call my healthcare insurance. She coached me beforehand and I called her after and we talked about it, or we could have done it on speakerphone. So you can still help support somebody in managing that ABLE account in the more unofficial way. And that's what we recommend also, because it gives people the ability to become more financially literate because you're actively learning those things because you have to. You know, there's a lot of importance on learning how to make a decision because you have to. You know, if somebody takes over all aspects of your life or most of the aspects or just a few, then a lot of people, like if somebody said, oh, Alicia, I'm going to do your laundry for the rest of your life, I'd be like, sweet. Okay, cool. I don't have to learn how to do laundry. I don't want to learn how to do laundry. You can do it. And so there's a big benefit in helping people along with learning how to make these decisions so that they're more capable to do that over time. Guardians or conservatives are required to disclose a bankruptcy that has happened within the past 5 years. Professional guardians must disclose rates. So if a professional guardian is going to be charging an hourly rate to act as a person's guardian, they must disclose rates now. This is part of the new statute. And if they don't know a specific rate that they're going to charge, they are required to give an estimate. More provisions on the guardian's ability to restrict social interactions. We already talked about that a little bit. A person under guardianship is to receive their statutory rights at every annual review. So guardians have to submit an annual report of well-being every year to the court. So every year, as you submit an annual report of well-being, you also have to make sure that the person subject to guardianship has their statutory rights and the Bill of Rights, and that's within their knowledge, and they have that information. Emergency guardianships can be extended once. So emergency guardianships happen most often when it's an emergency and somebody is of physical harm or is of harm and it needs to happen really quickly, right? So emergency guardianships can only be extended once, 60 days at a time. And this is to continue that conversation forward, and is an emergency guardianship needed or a permanent guardianship needed, or can this person be supported through alternatives? A guardian can now represent a person under guardianship in court. So there's a whole list, which I don't have in front of me right now, but a guardian can represent somebody in court. And then control over wages. So this means that the person subject to guardianship has full control over the wages, which has always been the case, right? Because guardians have not had financial power over somebody's finances. Because guardianship is guardian of the person and their decisions, and conservatorship is decisions over somebody's estate. So typically people with intellectual and developmental disabilities don't have the estate that would constitute the need for a conservatorship. So usually people can be supported through other ways of financial support, like an ABLE account or a representative payee or joint bank account. So to clarify, the control over wages, guardians have never had to have that, but it's more clear now that people have control over their own wages, and that's the same in a conservatorship. So even if a person is under a conservatorship, they still have control over money that they make themselves through employment. And the additional changes in statute also require more communication with all interested parties. So this would be immediate family members and anybody who's an interested party, and that definition is in statute as well. So that is a high-level overview of what statute changes and have happened to modernize guardianship in Minnesota. Of course, this webinar today is a great resource. Next month, I will be doing a webinar overall on what supported decision-making is, what limited guardianship is, what the full guardianship is, to update that information. We also have created a guardianship reform fact sheet. So if you would like this information in a written format, we have 2 pages where we have listed out all of these changes. And also our team just created an ARC guide to decision-making options. So that is another resource, more in-depth as well.
Thank you so much, Alicia. As you guys can tell, Allycia Wolff is really our resident expert at the ARC about guardianship, the various decision-making options that are available to people. And so we are really grateful and fortunate to have her expertise in these matters. So now we're going to move on to the Q&A portion of our event. There are lots of great questions that have been submitted in the chat function already. We'll start with those. Our colleague Chloe Alf is also monitoring the Facebook live stream. So if you're watching through Facebook, you can submit a question in the comment section, and Chloe will make sure that that gets to us as the presenters. So the way we'll handle this is that I'll read some of the questions that are coming through in the chat, and Alicia and I will kind of tag team on the answer. I do want to preface that Alicia and I are not attorneys. We are not legal experts. So if you have more intensive questions about some of these changes, we can help connect you to legal experts if you need it. I also really encourage you to reference some of those written resources that Alicia mentioned that do offer a more comprehensive snapshot. And we'll also be working to share other informational guides about these changes that are coming from the Minnesota Disability Law Center, Elder Justice Center, Wings Minnesota, etc. So this is not the only opportunity to ask a question today. Again, this is not the venue for any specific legal guidance, advice, expertise that you may have about a specific guardianship. This is really about some of the changes that were made during this past legislative session. So I just wanted to be sure to give that kind of caveat. The first question in the chat was, will time-limited guardianship be phased in? I believe that Alicia did address that in her comments. The time-limited mandate on guardianships for individuals who are younger than 30 is not retroactive. So that will not affect any current standing guardianship orders. It's only for guardianship orders that are being approved after August 1st. So that's kind of the phase-in period, if you will. Again, it's not changing any standing guardianship orders. You won't have to go back after 72 months to secure another guardianship if you have a family member or someone you support that does have a guardianship already. Alicia, anything to add, or do we pretty much cover that one?
I think that's about it. Yeah, thanks.
Okay. Laura said, and I'm just going to read these comments directly from the chat. My daughter will always need a guardian due to her severe cognitive disabilities. Doesn't this place a larger burden on the guardian or family? Because now we have to reapply for guardianship every 6 years. So we will have to pay for attorney fees each time. That's the first part of the question. So maybe we'll start with that first part of the question. Alicia, what would you say to that?
Absolutely. So this is a point that a lot of families are bringing forth to us, and it's something that Alicia and the team of people definitely had in mind when they were doing all of these statute reforms. And it wasn't intended to make it a more difficult process for people. It was intended to make it so that people could retain more decision-making rights over time. And the reality of people that identify as having an intellectual or developmental disability is there's a wide range of people and different different decision-making abilities and different strengths over time. So the statute, of course, isn't ever going to be able to perfectly accommodate every person in Minnesota who is going to be subject to these. So in the case where a person has guardianship at 18 and then they have to go back 6 years later, and then again, it is required to do so. And if your county has financial assistance and support, that is something that you could utilize each time that you do that. So there's a process called IFP, in forma pauperis. IF as in Frank, P as in Paul. It's an old Latin term, but in many counties in Minnesota, people could utilize IFP, which is where the court waives the court fees and pays for the attorney to support people through this petition. So in many counties, it isn't necessarily as high of a financial burden as many would think initially, but it is an opportunity for families and for people and for caregivers and for courts and judges and everybody to really examine if it's continued to be needed and necessary.
Yeah, thank you, Alicia. And I would just kind of make mention too, it's not that you have to go back every 72 months for the duration of an individual's life. It would be that preliminary guardianship order determination. Thereafter, you'd have to renew after the 6-year period and then again. So if a guardianship order was renewed and then you kind of met that time period threshold, after that, you really could have a guardianship order that would be standing for the rest of an individual's life. But a lot of things change in people's life over the course of 6 years. And I think the expectation that has been set for people with disabilities nationwide is that they definitely need a guardianship, that everybody with a disability needs a guardianship. And there are so many diverse options that have a really great opportunity to offer a tailored, individualized level of support. So again, it wasn't to make this even more burdensome, even more restrictive. It was really to have an opportunity to consider those less restrictive alternatives that don't require significant attorney fees, that really don't mandate that you go to court, right? Some of those really expensive and stressful processes can be avoided if a less restrictive alternative works for you, or a combination of those different supports. So, our team is here to provide some support as you consider decision-making options, no matter how much support an individual with a disability needs with their decision-making.
Even if people don't use words to communicate, there's still a lot of ways to support people in making decisions and understanding what decisions are ahead of them. And if you think also about what can all happen and change in the course of 6 years, if I look at how my life was 6 years ago, it was incredibly different. And so that's a really good amount of time to be able to help somebody learn more and deeper about their life, what kind of help they need. And it allows for a good amount of time to develop who is in your life who can help you make those decisions. Who's in my life right now is very different and also very similar than who was in my life 6 years ago. So the hope, again, is to continue that conversation.
The second part of Laura's question was about whether her daughter's Social Security benefits could pay for the attorney fees. And Alicia did mention one financial support option, IFP. But Alicia, do you know if Social Security benefits can be used for that?
I don't know. I don't know specifically. I would say ask the attorney. I wouldn't want to say one thing or the other at this point without being completely certain.
Okay, a similar question came through from Joy. Joy said, for people that are guardians for severely disabled people with multiple comorbidities, this has added many additional layers of bureaucracy for the parent or caregiver, taking away from the care of the person. Please address how these people were accommodating or in this legislation. You know, again, certainly this was not intended to create any additional layers of bureaucracy. Really what it's intended to do is come from a place of presuming competence, assuming and presuming capacity for individuals, and considering all of the ways that we can tailor decision-making supports, including guardianship, for people no matter the level of support that they need associated with their disability. It's just so critically important that we consider that range of options, those less expensive options, those options that don't force you to go through a formal legal process. They're out there and they're so robust. And the more that we learn about them together, the more that we see the options that are available for people with disabilities in making decisions across all areas of life. So again, we really, really feel like this was a change in the right direction. There may be some additional processes that people need to go through, but I think that's an important check and balance in the life of people with disabilities, again, to make sure that we are putting them at the center and their capacity for decision making at the center whenever and however possible. Alicia, would you add anything to that?
You could also look at the perspective of potentially this change leading to less bureaucracy. I have had many conversations with people who are 25, 28, 30 years old who had a guardianship when they were 18, and they're calling me now and they're like, hey, how do I terminate this guardianship because I don't need it anymore? My guardian is actually, like, if they're a professional guardian, I can't get a hold of them, or they don't know who I am, or you know, I don't want my parent to have this level of control over me anymore, and I really don't feel it's needed. And so through that conversation, we have to talk about what the termination of guardianship process is with the courts. So for people that would fall into that, you know, situation, it would lead to more opportunity to have an easier time to look into alternatives to guardianship and less restrictive options.
Thank you, Alicia. Sue asked, how will all of the folks involved in guardianship, attorneys, judges, family members, and other guardians be educated on these changes? Well, that's a really good question. The ARC Minnesota is really taking a lot of action to make sure that our stakeholders are educated and informed about these changes. I know that the team from the Minnesota Disability Law Center is working on some resources for other attorneys. I believe that other Wings Minnesota members are developing some tools and guides and resources. And of course, the courts were involved in oversight of the bill language. And so the courts will also be sending out some information to judges about these changes. So we really do want to make sure that stakeholders across the spectrum of the guardianship process are well informed. Alicia, anything to add?
You got it.
Mary asked, how difficult will it be to move from guardianship to a less restrictive option? Is there a path to do so? That's a great question. I'll turn that one to you, Alicia.
So if it would just happen to coincide with the time of the time-limited guardianship, then it would be a pretty easy transition, and you just wouldn't go back to court to petition the need for a continued guardianship. And you would have conversations about which of those less restrictive options would fit somebody well. So the transition from guardianship to no guardianship could happen pretty easily if it just coincided with the time of the time-limited guardianship. You could also have continued conversations of how can we build these supports, the supported decision making, while somebody is still utilizing guardianship towards the end of that time limited, so people understand what those supported decision making options are and what those less restrictive options are as they transition from guardianship to no guardianship.
Thanks, Alicia. Joy asked, why do I now have to complete our guardianship renewals through an online process? We have a relationship with an attorney that has managed this very well. Will this have to change?
So the My Minnesota Guardianship, it is an online format that people can use to submit their annual paperwork for guardianship, but you don't have to. You can still report it via paper format, but for a lot of people, having the access to do it online provides an easier route, a more consistent route, and you're able to track those papers better and easier because you're not mailing it in. So it is an option, but it's not the only way that you have to do it. And then often, I don't know about your situation, so this could or could not be true, but sometimes when attorneys do the annual report of well-being paperwork for caregivers that are supporting somebody under guardianship, sometimes attorneys will charge a fee for that. And it's a really simple form that is really just your information as a caregiver, and it takes probably 15 to 20, maybe 30 minutes to fill it out. So it was also a hope that this online format would make that more accessible to people so that they also wouldn't have to pay for that fee.
Thanks, Alicia. Paris asked, is this webinar recorded? Yes, we are recording this webinar. We will make a recording available as soon as possible. Thankfully, the Zoom feature uploads videos very quickly. And with Karen's support from Access Resource, we will also have captions available on the recording. So we will be sure to share a recording of the webinar on our social media networks. We will also post it on our website. And of course, we'll also share a recording in our upcoming public policy newsletter, the Capital Connector, which I really encourage everybody to sign up for. For instance, we had shared information about some of these guardianship changes in previous policy newsletters. So that's a really important tool and resource for more information about public policy work and legislative changes like this. Kelly asked, can you please send these printed resources, including the presentation today, to all attendees? Unfortunately, Kelly, we wanted to make sure that the webinar was as accessible as possible to people, so we did not require people to register in advance. Because we didn't require registration in advance, we don't have contact information for participants. However, you can contact us directly at the ARC and ask for some of those resources. Again, we will also make those printed resources available on social media, on our website, and through our public policy newsletter. So they will be available in a couple different ways.
Thanks, Alicia.
Yeah. Becky asked, could you give an example of how you would write about the alternatives tried? 4C on the petition form says less restrictive means have been attempted and considered, but are not sufficient to meet the respondents' identified needs. The description of what has been attempted and considered, how long less restrictive means have been attempted, but have not been sufficient to meet the respondents' needs are listed below. This is an example where I would really suggest that you consult with an attorney when filling out those kind of petitions and those other legal forms. That begins to kind of get outside of the ARC Minnesota scope. Again, we don't want to provide any guidance that would be misconstrued as legal guidance or advice. So that would probably be your best bet in response to that question. Alicia, do you have a different take on that?
Absolutely. No, you're absolutely correct. In general, we recommend that if people are going to do a limited guardianship or a guardianship, that we really recommend that people work with an attorney, because it takes specific language to explain, just like you mentioned, like what exactly does it have to say to prove that we tried alternatives before leading to a guardianship. So attorneys know what needs to be in that petition. They know how to say it, and they know how to say it in a way that's not going to give too much information, because the guardianship petitions are public record. And so the attorneys know how to write the information so that it is deemed as a need, but it's not giving too much information. So reach out to an attorney. They'll be able to have that specific language. Yeah.
A question from Joy. We currently renew guardianship every year. Will this change? Again, I want us to try to avoid providing responses about individual specific guardianship orders. We don't have all of the information about the way that guardianship has been structured, and so don't want to provide any misinformation for people. If you have more intensive questions about a specific situation that you are in a guardianship for yourself or someone whom you support, you can reach out to us at the ARC Minnesota, and we can talk through that more in depth. Again, it's hard to understand the full detail about a guardianship that's specific to you in this time period. So Alicia, what would you say?
Yeah, absolutely. Reach out individually. I would love to have a conversation with you about, the specific situation and how it affects you. And just for clarification, when you submit that annual paperwork for annual report of well-being for that annual paperwork, it's not that you're petitioning for the guardianship again because you're not going to court. You're just telling the court that, like, hey, I have been acting as a guardian and it's my opinion that this is still needed.
Okay, the next question from Laura. Could you please say more about not necessarily needing to renew guardianship every 6 years for the person's lifetime? Yes, so time-limited guardianships are now mandated for young adults who are going to be subject to guardianship from 30 and earlier, right? The time period upon which that first guardianship order is placed is 72 months. After 72 months, you'd have to go back and take a look at whether a guardianship would be needed and kind of figure out what other alternatives could be tried before a guardianship would need to be renewed. At that point, if a guardianship is still needed, then that could be extended beyond a 6-year period. Alicia, would you offer any more clarification?
It's beautiful. Thank you, Alicia.
So from Sarah on Facebook, I'm a mom and guardian of my son. Son's brother and sister are thinking they should become guardians also. I got guardianship so he could get services when he was in his 20s. We mainly do guardianship because it's what we know, but we mainly support him. I'm also a rep payee and also have joint accounts with my son. Thinking it might be possible to just do POA and do away with guardianship. Is this possible? That's a great question.
Yeah, that's great, Sarah. I think that it's wonderful that people are starting to question, hey, is this guardianship needed? That's what Alicia and I have put so much work into to really change the statute so that, it affects people on a day-to-day basis. And it's a beautiful thing that you're reconsidering how to support somebody in the best way possible. Because while you have a guardianship now and it's, working, it also is a guardianship that is restricting rights of a person that doesn't necessarily maybe need that restriction of rights. And I think that there's a lot to be said in the personal autonomy and dignity that one has when there is no guardianship at play, even if it's a situation where the guardians aren't really utilizing it as like a traditional guardianship. Just the fact that it's still there can, lead to different feelings for the person who's under guardianship. So to change that now, I really encourage that you think about the specific ways that the person that you're supporting needs support. And you could even write it down. So you could say, okay, well, I know that they need support in talking through medical things, like what medications they're taking and which doctors they go to. And I know that they need support in this and this and this. And then you can look at those and you can say, what level of support do they need? Do they need a power of attorney? Could we get by with just a release of information. So then you're really determining what kind of support matches with what the person needs. And then you have a perfect case to go back to court and be like, hey, we don't need this guardianship at all because this person can be supported through this, this, and this way. And the judge is going to be like, sweet, let's do it. Because you are listing out all of the people that are in a person's life who want to be there to support an individual, and you're proving that a guardianship just isn't necessary anymore. It does require a court process because guardianship is a court process to begin with. So to be able to terminate that guardianship, you have to go back. And that's because there is no time limited piece on yours. So, and if you want help talking that out, just call me. Happy to help.
So I'm mindful of the time. We have about 4 minutes left and a couple of questions left. Again, if you have more questions, please feel free to contact us at the ARC, and Alicia and our team members can provide more in-depth support. But Amber asked, how soon do we need to have these supports in place before the person turns 18? And I think this is one of those questions that it really depends on the person, right? Generally, we really encourage that families start thinking about all of their decision-making options very early. I mean, even before this individual is transition age. It's so important to start thinking and supporting children with disabilities at a very early age about how, how can they maximize their independence? How can they maximize their decision making, even in little ways through school that can help transition into adulthood? So Alicia, what would you say about that question?
Yeah, you said that so well. And it's really giving children and young adults the opportunity to flex those decision-making muscles. And parents are asked to do so many different things. So it is just another conversation in how to really help somebody know what it takes to make a decision and be able to feel supported in that over time. And the courts now are going to ask, what less restrictive alternatives have you tried? And how long have you tried them? So, and that could be like a very intentional try and to require the need for a guardianship. But if the point in the court asking that also is just to see how it goes, right? To see how it has been tried. So then families can be like, oh, hey, this actually does work. I don't need a guardianship, right? So it's on a case-by-case basis. But it's really encouraged to give people the dignity and autonomy to make those decisions as early as possible.
Becky said many families are writing their own petitions, and I believe that was in response to a previous question about how to fill out a specific section of the petition. So again, Becky, reach out to us. We can maybe chat more about this in depth, provide some specific triaging, and work through your questions together and give some options and or help you get connected to some attorneys that could just provide guidance in the drafting process, not necessarily take over the entire petition, but really offer more specific support to you. The last question that we'll have time for today is from Laura. Has the petition for guardianship form changed prior to August 1st or after August 1st? And many of the changes really went into effect on August 1st. So there are some changes that have different effective dates, but the majority of the changes did go into effect on August 1st. I think we want to just note that thank you to Ruth for this comment. Ruth said each case and family is unique, so one size won't fit all. Thanks so much for the hard work in this reform. And thank you. That's a really uplifting comment. We really appreciate that. As Alicia mentioned, we at the ARC really do believe in the capacity of people with disabilities of all ages. We really understand the need for a strong and robust community of supports for people with disabilities and for those of us who don't have disabilities, right? We all make decisions together in groups alongside trusted partners, whether they're friends, family members, professionals, and we really want that to be reflected in the decision-making process for people with disabilities as well. So that was really at the core of these changes. That was at the heart of driving our work on this guardianship reform. Alicia, anything that you would add in final closing comments?
Thank you, everybody, for taking the time to be here. Thanks, Alicia, for pushing this policy forward. I myself take guardianship calls and lead that effort, and we have a few other staff who are more than happy to chat with anybody at any time about things that they have questions on. So feel free to call us and look into our resources, and thanks for everybody. And we really do feel like this is a really exciting change, and we're happy to be a part of it.
Yeah, thank you all for taking the time out today. Again, we will make this recording with the captions available on social media, on our website, and in our public policy newsletter. You can also find the printed resources or the electronic resources that we mentioned earlier, that fact sheet about the guardianship changes, and the new ARC guide to decision-making options in all of those places as well. Again, don't hesitate to contact us at the ARC for more individualized support and advocacy. Thanks everybody for your time today, and stay well.
Thanks, everyone. Bye.